So welcome on stage. Pauline, the stage is yours.
Yes, thank you very much. I just want to give a quick update regarding the decision of the BGH, the court Planet 49 decision. And yeah. First, I want to give a short overview about the legal history, because actually it's not a new topic. It's a really since May 2011. It's discussed whether cookies need the opt-in or opt-out. And the history is that in the earlier version of the e-privacy directive, there was written down an opt-out. So you just had to inform the user in your privacy policy about the setting of cookies, but and you had to give the opportunity to opt out for the users, and the directive, that is the difference to the regulation of the GDPR. The directive has to be transposed in international law, and in German law it's written down in the Telemedia Act, the TMG, and of course it was also written down in paragraph 15, para 3 TMG, that you have to inform the users and to give the opportunity to opt out. So now then, the revised version of the e-privacy directive said you now need an opt-in of the users, a prior opt-in. So any cookies or similar technology which are not necessary, not technically necessary for the website, you need now an opt-in. And yeah, so the problem was that some member states understood the regulation different, and in Germany it was still the opt-out mechanism, and the TMG was not changed. There was a draft bill in 2012, but it never was yeah it just still was a draft bill, and nothing happened. So it was still the same regulations than before in Germany. And the revised directive should have been transposed into national law by the 25th of May 2011. And since then, there is a great discussion whether German law, the national law, is compliant with the privacy directive or not. And also the data privacy authorities, the data protection authorities, said in 2015 again that cookies are only or need the prior consent of the user if they are not technically necessary for the specific website or whatever. So that is the history. So it's really long discussion and not new, but I realized that the data protection authorities try to build it up as a new topic in connection with the GDPR, but actually it's not. So then I want to give you an overview of the course of proceeding of the Planet 49 court process. It started already in 2014 that the Landgericht Frankfurt am Main said you need a opt-in, a prior opt-in for the setting of cookies for advertisement or marketing purposes. And then the next higher court, the Oberlandesgericht Frankfurt, said in 2015, no, you don't need a prior opt-in, a prior consent, opt-out is fine. So you just have to inform your users in the privacy policy and to give the opportunity to opt out. Then the next court, next higher court, the BGH, Bundesgerichtshof, said, okay, maybe we have a problem with the e-privacy directive. We have to ask the EuGH, European Court, whether it's there is a necessity of opt-in or opt-out is fine. In 2019, the EuGH decided in October 2019 that you need an opt-in, an active opt-in, so opt-out is not compliant with the e-privacy directive, and they gave the decision back to the BGH, who has to decide again in this case, in this Planet 49 case, and they decided that Paragraph 15 Absatz 3 TMG, so the German law who relates to the setting of cookies, has to be interpreted in compliance with the e-privacy directive, and you have to read this regulation now as an opt-in. And that was in one point of view, it was good because the data protection authorities always said the TMG, Telemedia Act, wouldn't count anymore. The GDPR would be the only law which is yeah, you have to comply with. And so on that point of view, we won a little bit because we could say the data protection authorities were wrong. But on the other side, of course, we need an opt-in now, and a prior opt-in and active opt-in. And of course, we saw that kind of decision or that kind of future we saw already, because otherwise we wouldn't be as that far as we are at the moment with the CMP. But yeah, so we see it as a long discussion already, and the court discussed that as well for 6 years already. So now I just give a short legal overview. And I just wanted to clarify again that the e-privacy directive is not the same like the GDPR. It's two different regulations. And the e-privacy directive is important for the cookies, because any storage of information or any access to information already stored in a user's terminal equipment is according to the or portion to the e-privacy directive subject to the legal requirements and to the consent. And it's written down in Article 5, Para 3 of the e-privacy directive. And the storage and that doesn't or it's regardless, the consent is necessary regardless of whether this information is personal data or not. anytime I storage any information or access any information which are on the user's terminal equipment, I need this consent. So, and if these information are also personal information in the meaning of the GDPR also apply, but additionally. And the e-privacy directive and the GDPR also have different areas of application and protection purposes. That was also ruled out from the EuGH and the BGH as well in the court decisions. They made clear that the e-privacy directive has another protection purpose than the GDPR. Yes, and I tried to with the symbols in the in the bottom, I tried to make it clear. So the protection purpose of the e-privacy directive is to protect the user against any intrusion into his privacy by accessing his terminal, whether or not it's personal data or not. And the GDPR protect personal data or personally identifiable data. Okay. And also I heard a lot of times also from lawyers that the questions whether we can use cookies on the basis of legitimate interests, and so I just want to make clear the GDPR with a legitimate interest. This is one legal base mentioned in Article 6 of the GDPR. It's only applicable on the processing of personal data. It has nothing to do with the setting of cookies. The question whether I need a consent or not is written down in the e-privacy directive, and there is only consent or no consent. There is nothing else. There is no contract, no legitimate interest, no legal responsibilities. I just have to look, is there a chance to say this cookie is technically necessary, and if not, I need a consent. And regarding the information I have to give the user for informed consent, it is also a little bit different from the GDPR, but the courts make clear in the Planet 49 decision that the duration of the cookies function, and also whether the cookies are third-party cookies or first-party cookies are necessary for the user to decide whether they give their consent or not. And regarding the rights of the user, also with cookies, the user also needs to have the right of revocation of its consent. And regarding the GDPR, we have a lot of more. Yeah. I hope I'm not too fast. Maybe you know already all that stuff. So short overview principle, you need also always prior consent when you set cookies, and the previous opt-out is history. And paragraph 15, section 3 of the German Telemedia Act is still applicable, but you have to read it now as an opt-in and not as an opt-out anymore. And you see it also in the cookie banners. They changed because I just built up some cookie banner you could see in the past a lot of times. That was more just an information. Because the most websites already set cookies in the moment you visit the website, whether or not you press the button OK or all right, and you just had the chance to opt out via clicking links in the privacy policy or something like that. So these kind of cookie banners are history. It's not compliant with the e-privacy directive or with the TMG anymore. So now the cookie banners looks a little bit different, and we have the nice cookie banner of a build here on the right side, but also some other which are maybe not compliant with the TCF, but you can also use cookie banners like that if you have no TCF vendors on your website, and it might be not that important to use a TCF compliant cookie banner. Yes, this for example. And I also we have some information on our data privacy site on Axel Springer, and publish there some info sheets, and also the nice handbook best practices for cookie banner and CMP design under TCF 2.0, which was built up from my colleague Olaf, who's in the call as well, and also some short information you can inform you there as well. And in the end, I just want to say 3 points. I mentioned that they're often forgotten because the CMP, as Julia already said, it's a big and complicated structure, but you have to ensure that the information in the privacy policy also are in compliance with the CMP. So please don't forget to update your privacy policy when you go live with the CMP, because normally the privacy policy still have the opt-out mechanism inside and some opt-out links. So you have to update the privacy policy and make sure that the information in the privacy policy do not contradict the information in the CMP. And also, please ensure that the imprint and the privacy policy are available at any time. So we decided, for example, on Welt that we just linked it in the CMP as well, because the CMP is here overlaid on the website. You cannot scroll down till the button where you could find the privacy policy and the imprint. So that would be a possibility to ensure that it's always available. And also, please ensure that the settings in the CMP must be available at any time for the user. So, and we also say in the cookie layer here, and also in the privacy policy on Welt, that the user can change or can change its settings, and therefore can revoke its consent by in the CMP at any time. And therefore we have to ensure that there is a link to the CMP, similar to the privacy policy or the imprint in the footer, for example, of the website. And yeah, I just show you here where we realized that on Welt. Yes. I don't know, do you see now the website?
So I see your slide.
Do you see the website now? No.
No.
Still the slide.
Okay. Okay.
Do you want to show it? Then you have to cancel
Yeah,
the sharing and then share again your screen.
Yeah, share again. So now you can see it, right?
Yeah.
So we have here the privacy policy and here the imprint. And here also the information that the settings can always be changed in the privacy area, in the Privatsphäre. And yeah. And for example, in the privacy policy, I can just show you some areas we changed, like we have the information what happens when you visit the website, and normally we had there cookies like also the IDFA and something like that, and now there's only cookies, and in the brackets there is Sonderkategorien, means technically necessary cookies, because all other cookies are only set subject to the prior consent of the user. And we I just scroll down, sorry. Yeah, here it starts. We have some information for cookies and similar technologies, and then we start with the purposes of the TCF, and then we just list the vendors who use this purpose. And that's what it from my side.
Thank you, Pauline. Are there questions? Let me check the chat. Okay. So there's the first question from Felix. What are the boundaries of technically necessary cookies? Naming an example, imagine, is that still a question for our tech guys, or is that a question, Felix, for Pauline?
Maybe into the round, but Pauline just mentioned the technically necessary cookies, and I would just wanted to know if somebody has a more broader idea of the topic.
Yes, there are, for example, the typical examples from the data protection authorities are the login cookies, for example, when you log in log in a website area, and you to give the opportunity to change the websites, or to use different subdomains, you need a cookie who realize the user as a logged in user. Otherwise, he had to log in anytime you switch the site. So that would be, for example, a technically necessary cookie, or in a web shop, online shop, when you need cookies to for the process, for the shop process normally. But actually, it's a kind of, if you have good arguments why it's technically necessary, it's not really written down which kind of cookies are technically necessary or not. You need good arguments, but for sure you cannot argue that cookies for marketing purposes also are technically necessary.
Is there any way of finding more insights about technically necessary cookies? Like, what's the current take on it? Yeah.
We have one information sheet on our DSGVO on our website, where we wrote down some use cases of technically necessary cookies. But
we have to keep in mind that not everyone has access to the Move office.
Okay, but then you just can write us, and you can write at Leo, for example, Leopold Levicharov, if you know him.
So Pauline, let's keep it like that. We gather all the information, and then we will provide it through our team here. Yeah. And then everyone can take it from there, because there are a lot of people here in this round who don't have access to the Move office, also to the link that Kerstin posted. So we will take care of that, or we will get in touch with you. Yeah. And then provide all the materials here in our expert exchange team. I think that would be the easiest one.
Okay, and I also want to say regarding this information sheet I mentioned, it doesn't mean that any other cookies are not technically necessary. So it's just a example, and we still are working on a paper that we give more help or more information, what you can to decide whether a cookie is technically necessary or not.
So I think, Ben, your question's answered with that, right? So if we post all the...
I'll get in touch. Yeah, I'll get in touch. Yeah. Yes, perfect.
Okay. So Florence is asking, do you know if you will have a guidance from the group in the coming month regarding the future cookies developments?
Yeah, we are in a close we nearly speak every day about the cookies and which are technically necessary or not, and we draft another info sheet or something like that to give an overview or to help to decide.
That is great, thank you.
So then, Kerstin, thank you for posting the link to the GDPR e-privacy team. So this could also be the best place to find all the materials. And then Klaus is asking concerning the DSGVO fact sheets For a few weeks by now, I'm unable to access them via the AS contract tool. Let me see, sorry. The link to the PDF files is still not working. Tried with different browsers. Is the problem known and addressed? Does anyone know?
I think
Okay.
it was answered already by Kerstin, right?
Yeah.
Look into it. Thanks for the info. Yes.
Yeah.
Okay. So probably we will post it also in our team.
Yeah.
Then that you have all access to that.
Yeah.
As extra.
Okay. Here are some more like organizational topics. So we will take care of that and let you know throughout our team here. Good. So, any more questions for Pauline? No. Okay, then I would say let's move on.
Thank you so much, Pauline.
Yeah, thank you.
You're welcome.